My name is Edmond Leung. I'm a partner at Tanner De Witt in the corporate and commercial practice. I will briefly talk about warranties and indemnities in relation to merger and acquisition transactions. Warranties and indemnities are forms of contractual protection that a buyer will usually include in the sale and purchase agreement for the acquisition of shares or for a business and its assets. A warranty is a promise that a particular statement made is true at the date of the contract. If such warranty turns out to be incorrect, the buyer may seek damages, i.e. compensation, for breach of that warranty. For example, if the seller has given a warranty that the target company is not involved in any disputes or litigation, but after completion of the purchase of the shares, the buyer discovers that actually it is, then there is a breach of that warranty. Whether a claim for breach of warranty can actually be made will depend on the terms of the sale and purchase agreement, and whether loss has been suffered by the buyer as a result. Areas covered by warranties include, without limit, title to the shares being purchased, the target company's financial statements, its banking facilities and finances, employees, contracts, litigation, solvency, and so on. Warranties serve two main purposes. First, they provide the buyer with a remedy for breach of warranty, if the statement made is incorrect. This provides a form of retrospective adjustment of the purchase price. But note that, as previously stated, whether a claim for breach of warranty can actually be made will depend on the terms of the sale and purchase agreement, and whether loss has been suffered by the buyer as a result. Second, warranties encourage the seller to disclose facts and circumstances that are inconsistent with the warranties. If such facts and circumstances are properly disclosed, then the seller's liability can be limited to the extent proper disclosure has been made against the warranties. Indemnities. An indemnity is a promise to reimburse the buyer in respect of a liability that arises. An indemnity allocates the risk of a particular matter to the seller and allows the buyer to recover loss on a dollar-for-dollar basis in respect of the matter covered by the indemnity. For example, there may be ongoing litigation against the target company, and if the target company loses that litigation, the seller indemnifies the buyer for all losses and expenses arising from that particular litigation. Indemnities may be included for specific issues or matters relating to a target company that are discovered through the buyer's due diligence, exercise relating to a target company, or through disclosure against the warranties. Indemnities are useful where warranties may not allow the buyer to recover losses for a particular matter, for example, because a matter has been disclosed, or in the purchase of shares where breach of a warranty may not result in a reduction in the value of the shares. Therefore, no claim may be made for breach of warranty, as there has been no loss. Examples of matters covered by an indemnity include the target company's taxes, or where there is a particular dispute on foot, or where the target company has failed to comply with certain laws, for example, employment laws. You will typically find warranties in a sale and purchase agreement can run to some 30 or more pages long. Indemnities, too, can be extensive. This is because the buyer of shares or business and its assets enjoy very little protection under law if what has been purchased turns out to be not what was expected. This is, of course, subject to certain exceptions, such as misrepresentation or fraud by the seller, but claims for misrepresentation can be limited by the provisions of the sale and purchase agreement. The principle of caveat emptor applies. Caveat emptor means let the buyer beware, so the buyer purchases at its own risk in the absence of an express warranty or other contractual protection in the agreement. Therefore, if you are buying a company or business and its assets, warranties and indemnities are important. This is regardless of whether the sale and purchase is of shares or business and its assets. With a purchase of all the shares in the company, the buyer buys the company lock, stock and barrel, that is, including all its liabilities. With the purchase of a business and its assets, unlike in many other jurisdictions, in Hong Kong, the debts and obligations, including liability for tax, of that business will transfer to the buyer by virtue of the Transfer of Businesses Protection of Creditors Ordinance. That is, unless the notice procedure under that ordinance is complied with. So who gives the warranties and indemnities? It is common for the seller to give the warranties and indemnities. Nevertheless, where the seller is a company, the buyer may consider whether another party, such as the parent company or the ultimate beneficial owner, should guarantee to the buyer the performance of the seller's obligations under the sale and purchase agreement. This is because if the seller is a company with little or no money or assets, the extensive warranties and indemnities in a sale and purchase agreement may in fact be of little value. Finally, sellers would usually look to limit or exclude their liability for breach of warranty, and sometimes under any indemnities. Disclosure of facts or circumstances that are inconsistent with the warranties is one way of limiting or excluding liability. Provided disclosure against a warranty has been properly made, the buyer would have difficulty bringing a claim for breach of that warranty. In addition, a seller would include provisions to, for example, limit the seller's aggregate liability to the total amount of the purchase price received, or to limit the seller's ability to bring a claim if it is not brought within a certain period of time. In addition, there may be what we call de minimis provisions, which means that claims below a certain threshold cannot be brought by the seller. So during the negotiations between the seller and buyer, quite some time and effort will be spent on the warranties and indemnities. Whilst this may seem tedious, these are nevertheless important aspects of a merger and acquisition transaction. Thank you very much for listening.